Today we're focusing on warranties, which serve as essential assurances in contracts. They ensure that goods or services exchanged will live up to the expectations set by the parties. These promises about quality, fitness, or title help maintain the integrity of bargains, and they align with the core principles we've been exploring so far, such as mutual assent and efficient risk allocation. As always, we'll ground our discussion in the black letter rules from the Restatement Second of Contracts and the Uniform Commercial Code Article 2, which applies specifically to sales of goods, those movable and identifiable things. By the time you're done, you'll have a clear understanding of how warranties form, how they protect parties, particularly buyers, and how they can be limited to protect sellers, all while tying back to the broader goals of contract law. To get us started, let's consider an everyday situation that illustrates why warranties matter. Suppose you're purchasing a new laptop for your studies. The product description online says that it has a battery life of up to 12 hours on a single charge. You rely on that when making your decision because you're going to spend at least 8 hours a day studying at law school and in the library, but after just a few uses, it barely lasts 4 hours. That discrepancy isn't just a disappointment. It's potentially a breach of warranty, and you might have grounds to seek remedies, like a replacement or damages. Scenarios like this highlight how warranties bridge the gap between what sellers promise and what buyers receive. And warranties promote fairness and efficiency in transactions. Warranties have deep roots in the evolution of contract law. In early English common law, the doctrine was caveat emptor, let the buyer beware. Purchases had little recourse when there was defective goods, and sellers could often escape liability, which stifled trust in markets. Over time, as commerce expanded, courts began implying protections that encouraged trade. A pivotal early case was Chandler versus Lopez from 1603. It involved a seller who warrantied a stone as a bezoar, believing it to cure poisons, but it proved worthless, obviously. This laid the groundwork for holding sellers accountable for their assurances. By the 20th century, the Uniform Commercial Code formalized these ideas, balancing buyer safeguards with seller predictability to facilitate modern economic exchanges. The Restatement Second reinforces this by treating warranties as integral to the promises that define contracts. Let's begin with express warranties because, in some ways, they're easier to understand because they're front and center, and they're detailed in UCC Section 2303. An express warranty is created by any affirmation of fact or promise by the seller related to the goods that becomes part of the basis of the bargain. Importantly, we don't need formal words like warranty or guarantee. It's the substance that counts, whether those are through descriptions, samples, or models. For illustration, imagine you're buying a pair of hiking boots. The store's website describes them as waterproof up to 10 inches of submersion, so you purchase them for a rainy camping trip, and they leak in a shallow puddle. This could constitute a breach of an express warranty, allowing you to replace the boots if the defect substantially impairs their value. Or you might be able to recover the difference between their warrantied value and their actual worth, plus any incidental expenses you might have incurred. However, not all statements qualify as express warranties. Mere opinions or puffery or sales talk, such as, "This is the toughest boot on the market," those don't create warranties because they're not verifiable facts. The distinction turns on whether a reasonable buyer would view the statement as a measurable promise. A case that brings this to life is Doherty versus Ash. A jeweler sold a diamond necklace and later provided an appraisal letter describing the diamonds as the finest quality. The buyer claimed the stones fell short and sued for breach. The court held that the letter created an express warranty, even post-sale, because it affirmed facts about the goods. It implied top ratings in the 4 C's: cut, color, clarity, and carat, and it tied those directly to the transaction. Notably, the buyer didn't need to prove specific reliance beyond the statement being part of the bargain because the quality of a stone is part of its value. And that emphasizes the UCC's focus on protecting reasonable expectations. But what if the facts were a little bit different? Suppose the letter said those diamonds shine brilliantly. That might lean toward puffery. That's subjective. It's nonspecific. And so it probably would not include a warranty that they were of a particular cut, like a brilliant cut. Or what if the buyer ignored the letter entirely, never read it? Well, in that case, the warranty actually could still hold if the affirmation influenced the overall deal. The fact-specific context matters, and these variations underscore the importance of context in applying rules regarded to express warranties. Moving to implied warranties, these arise automatically by operation of law, meaning without explicit statements from the seller. And the primary one is the implied warranty of merchantability. It's found under UCC Section 2304, and it applies when the seller is a merchant, which is important because it means that if you sell a used product and you're not a merchant, you may not have this obligation. Merchant, by the way, is defined in Section 2104 as someone who regularly deals in goods of a kind. And when this warranty applies, it requires that the goods must be fit for their ordinary purpose and be of fair, average quality within the description. They have to be safe for use and adequately packaged and labeled. Now, again, that's when the sale is by a merchant. So, take, for example, you purchase a can of soup from a supermarket. And a supermarket is a merchant in foodstuffs. So if the soup is spoiled upon opening, so it's unsafe to eat, that's a breach. The ordinary purpose of soup is safe consumption. Courts assess this against industry standards. Would a reasonable buyer expect the product to perform as such? And I think the answer is yes. You expect soup in a supermarket to be edible. The rationale here aligns with contract law's efficiency goals. Merchants, as experts, are in the better position to ensure quality and to bear the associated risks, which they could mitigate through insurance or vetting suppliers. This reduces the burden on buyers to inspect every item, and it fosters smoother market transactions. You might think of it as a default rule that parties would bargain for if there weren't inefficiencies in the bargaining process. A related case might involve a consumer buying paint labeled for outdoor use. If you buy it from Benjamin Moore and it fades and peels after a season, not holding up as ordinary exterior paint should, the warranty is probably breached. This encourages sellers to maintain quality standards, and it benefits the overall economy. Then there's the implied warranty of fitness for a particular purpose. You can find it in UCC Section 2315. This warranty activates when the seller has reason to know of a buyer's specific need for the goods, and the buyer is relying on the seller's skill or judgment to select or furnish suitable items. So here's an example to clarify. A gardener visits a nursery and explains they need fertilizer for a particular kind of acid-loving plant, like azalea. The clerk recommends a product, but it burns the plant instead of nourishing it. In that case, a breach might occur, provided that the reliance was reasonable. And this is true even if this was fertilizer that could be used for lawns. This differs from merchantability because of its specificity. It's not about the general fitness, but about the tailored use. And without the buyer's disclosure of the particular purpose, only the broader merchantability warranty applies. A compelling case on this is Tyson versus Ciba-Geigy Corporation, where a tobacco farmer, James Tyson, faced black shank, a destructive fungus. He told a sales representative he needed a fungicide to control it without harming his tobacco crop, and the rep recommended Ridamil. He applied it as directed. It not only failed to stop the fungus, but it damaged the plants, leading to major crop loss. The court found an implied fitness warranty. The seller knew the precise purpose, tobacco, protection from black shank disease, and the farmer's reliance on the expertise was evident. The decision turned on evidence that the product didn't suit the disclosed need. This case shows how the warranty protects buyers in specialized scenarios where sellers hold superior knowledge. Suppose the farmer had vaguely asked for a good fungicide and never mentioned black shank and never mentioned tobacco plants. well, then there probably would not be a fitness warranty. Again, just merchantability. And if it killed some fungus safely, it would probably be fit for ordinary sale. Or what if the farmer was an expert and ignored the rep's advice to the contrary? Again, no reliance, no implied warranty of fitness for a particular purpose. We should also touch on the warranty of title under UCC Section 2312. Every seller implicitly promises they have good title to the goods, meaning that they're free from undisclosed liens or encumbrances. If you buy a smartphone from someone and it turns out that they don't own it, the seller has to resolve that because that's a breach of this warranty. Regarding who can enforce these warranties, privity of contract traditionally limited claims to direct buyers. But UCC Section 2318 extends protection to family members, household guests, and anyone reasonably expected to use the goods, especially if there's a personal injury. So we have a little tort intersection here. Many jurisdictions have expanded this further, eliminating privity requirements entirely in warranty cases involving tort harms. Sellers, however, do have tools to limit their exposure to warranties through disclaimers under Section UCC 2316. To disclaim the warranty of merchantability, the language must mention specifically and conspicuously that there is no implied warranty of merchantability. And classic language for this would be a phrase sold as is, or alternatively, with all faults. Those sort of as is stickers that you might see on used cars are an express disclaimer of warranties, the kind of warranty you'd expect with a new car. Express warranties are harder to disclaim. If a seller actually affirms a fact and later tries to disclaim it with a contradiction, that's an ambiguity. Ambiguities are generally resolved against the drafter, as you know from our sections on contract interpretation. And courts won't let sellers give with one hand and take with the other. It's sort of irreconcilable to allow a disclaimer of an express warranty because we're going to hold the seller to the original words, provided there's reliance. And disclaimers aren't absolute either. They might be unconscionable, meaning unfairly one-sided, or hidden, like in fine print. And those can be voided under UCC Section 2302 or Restatement Section 208. In Henningsen versus Bloomfield Motors, a car maker's warranty limited remedies to parts replaced and excluded injury liability. Well, at least the contract tried to exclude liability for injuries, but the court struck that down as unconscionable. The buyer's lack of bargaining power and the policy favoring safety said that we were not going to allow a disclaimer against tort injuries like this. And once again, we see this tort contract smash up here. Upon breach, remedies include covering with substitutes and recovering the cost difference. We can also, as a buyer, reject non-conforming goods or revoke acceptance if impairment is substantial. And damages can be measured as the difference between the warranted product minus the value of the product as was actually sold. Consequential damages like lost profits are available if they're foreseeable, and Restatement Section 351 Consequential damages, like lost profits, are also available, but only if they're foreseeable, just like in other cases. And just like in other cases for damages, money damages, they're subject to requirements to prove them with certainty. And there's also the requirement for mitigation. So all of the doctrines regarding money damages apply here as well. From a policy standpoint, warranties effectively allocate risk to parties best able to prevent defects, which is typically the seller. They typically reduce transactions costs by minimizing pre-purchase inspections, and they build market confidence. Implied warranties set sensible defaults, reflecting what most parties would probably negotiate if transactions costs for negotiating weren't too high, while disclaimers allow for flexibility for low price or high risk deals. Yet, limits on disclaimers prevent exploitation, which upholds the voluntary, fair nature of contracts in the restatement. In today's world, challenges arise with hybrid contracts, which are contracts mixing goods and services, like installing custom software. And this is particularly true in states that have adopted the newer version of the UCC, which applies the hybrid transactions test that we discussed earlier. But in most jurisdictions, there's only about 8 that have adopted the new test. We use the predominant purpose test. And the predominant purpose test asks what is the dominant purpose of this particular hybrid transactions. If goods dominate, then the warranty applies. And if the services portion dominates, common law governs, and we don't get all of these UCC implied warranties. So a particularly odd situation is digital items. And the 2022 amendments on controllable electronic records treat some as akin to goods and extend warranty protections. But that's an advanced topic for another day and perhaps another year. In most instances, most jurisdictions still apply the predominant purpose test. So one of the reasons we care if the UCC applies is because if it does not, then we don't get the implied warranties that come along with it. So for those practicing or studying law, here's some guidance integrated into the discussion. When advising buyers, it's a good idea to document specific needs, because that would trigger fitness warranties, at least in sales of goods. And it secures express assurances in writing to strengthen claims. On the seller's side, you need to ensure the disclaimers are bold and specific to avoid invalidation. And you need to train staff to avoid unintended promises that could create express warranties. Always check for foreseeability in contract damages. Disclosing special risks up front helps meet this requirement that these harms are foreseeable by the counterparty. And in disputes, you'll have to verify certainty of losses with evidence, like market data, and confirm mitigation efforts. To test your grasp of this concept, consider this. If a seller describes fabric as flame-resistant, is there a warranty? Well, yes, that's likely an express warranty because this is a factual claim. Can it be disclaimed with a buried as-is clause? Probably not. And when you think about it, if you have flame-resistant infant clothing that ends up burning and adhering to a child's skin, public safety suggests that we would not want disclaimer of warranties like this. In summary, warranties are vital to ensuring the promises at a contract's core are going to be maintained and upheld. They ensure that bargains deliver value, and they evolve with commerce. They've evolved from historical lack of protections to a more modern system where buyers don't face caveat emptor. It's no longer let the buyer beware, at least in cases involving sales of goods, which is why it's so important to recognize if the sale of goods predominates at transactions because warranties attach. And by the way, as I mentioned, in some jurisdictions, the hybrid transactions test is a little more complex, where the warranty attaches only to the goods portion of the transaction in those jurisdictions. So we see it's still an evolving doctrine, a doctrine that's evolving as commerce changes, from historical lack of protections to a more protective regime to now a hybrid regime. And with that, I thank you for joining me for this discussion on warranties.